Helping Seniors Television, all about improving quality of life for seniors. If you're a senior, know a senior, or plan to be a senior, then this show is for you. It's all about helping you develop your own aging plan so you can age actively and with dignity. Helping Seniors Television from the Helping Seniors Network of information, education, and resources.
Welcome to Helping Seniors TV. This is the program put together by Helping Seniors of Brevard. Our mission is to educate, inform, and connect you to resources that make a difference as we create our own aging plan. As Joe Steckler, our founder and chairman emeritus, always talks about, you have to have a plan for things. And even when you don't have a plan, sometimes you have to make a plan on the run. And that's why I'm so excited to introduce our guest for today's program. She is one of two board-certified elder law attorneys here in Brevard County. Her name is Ruth Rhodes with Rhodes Law, PA. And Ruth, we're going to talk about crisis planning, which is almost an oxymoron right as you get there.
An oxymoron? Yeah, no, we are definitely going to be talking about crisis planning. But if you plan ahead, hopefully the crisis will be handled better and easier with less stress.
You know, you shared a story that you were explaining in front of an audience here at Joe's Senior Resource Center, and you were talking about the fact that oftentimes families will hit your office after they've been presented a bill from a nursing home that they didn't understand that they were going to be getting.
Yeah, so that is usually the trigger of the crisis for the family. So typically, I'm going to meet for the first time someone whose loved one has suffered some kind of health situation and is now in a long-term care facility or otherwise known as a nursing home. And they usually are getting rehab through Medicare, and they're running out of Medicare days, and they have just been informed by the nursing home business office that they're running out of Medicare days, and here's the bill for next month. And it's usually some very large amount of money. Usually in Brevard County, it's probably going to be around $12,000 to $15,000 a month. That they're going to be handed a bill for next month. And that's usually when panic sets in. And hopefully they call my office because I can help them figure out a solution, usually.
So really, as we're using the term today, crisis planning, there's two lines of thought, right? There's one is if you're planning ahead when you run into a crisis, which is obviously the best and appropriate way. And we really want to get into that. But then the other side is you guys are very adept at fighting a crisis when somebody finds themselves into it, even when they didn't plan correctly, or as we've talked about so many times, maybe they thought they had the paperwork in place that they needed and it just doesn't work when it needs to work. Where do you want to dive into the conversation? What's the best place to begin here?
I think the best place to begin would probably be the worst case scenario situation, right? Where very little planning has been done in advance, or you have planning, but it's defective, right? So in that situation, typically it's either a spouse coming in for their spouse that's going to be going into a nursing home, or it may be an adult child coming in for a parent. And the first thing I'm going to ask them is, do you have a power of attorney for your loved one? Because I need to make sure that they have the authority that they need to be able to do the Medicaid planning, right? So if they say to me, yes, then perfect. I will ask to look at it, and I will be looking for specific powers that will allow them to do Medicaid planning. And just depending on what we need to do for that specific plan will depend on whether or not that power of attorney is going to be good enough, right? So if they say no, we don't have a power of attorney, then my next question will be, does your loved one have capacity to sign a new legal document? If they say yes, then I'm going to be cheerful inside, and I'm going to move heaven and earth to try and get new documents signed so that we can get someone in place, right? To be able to make those decisions and help through the Medicaid process. If they say no, there's no capacity and there's either a defective power of attorney or no power of attorney. And let's just say that the Medicaid planning is going to require someone with legal ability to do the planning, depending on what the plan looks like. Then I will likely, the next conversation with them will probably be, I think we may need to file guardianship in order to get the legal authority for you to make these types of legal decisions for your loved one. And it doesn't matter if they're married. I know a lot of people think, well, that's my husband or that's my wife, and we've been married for 50 years. But depending on what needs to be done, the spouse may not be able to do it without a durable power of attorney. So it's all case by case. It's all depends on what needs to be done for that particular plan, but it's not unheard of for me to have to file a guardianship case just so I can do Medicaid planning.
Yeah, I know we've done whole programs talking about guardianship case and what all that entails. I just know, to keep it real simple for purposes of our discussion today, that A, it's very expensive, and B, as you pointed out, it moves slow because now courts have to be involved in every step of the way. And it's just not all that quick to get answers or get things to move. And then because of that, it also becomes very expensive.
Yes.
Yeah.
Yes. So guardianship is something that we want to try to avoid if we can. And what usually triggers a guardianship is there is a capacity issue, and I do mean like mental capacity issue, maybe a physical capacity issue as well, where that person is unable to make their own financial decisions, legal decisions, or healthcare decisions, or something along those lines. And they don't otherwise have legal documents that allow someone to do it for them. Usually that's going to be a durable power of attorney and maybe also a designation of healthcare surrogate. Right. And when there's lack of capacity, then the person can't sign new documents. So then we may need to talk about guardianship to get authority for somebody. And that involves 2 court cases, a mental health case and a guardianship case. So there's double filing fees involved. There's always going to be attorney's fees because you'll need to have an attorney to do the case and get the case started. And then the loved one that's going to be the subject of the guardianship, which is eventually, if there is a guardianship established, they'll be called the ward. They also get an attorney appointed to them by the court. And it's not free attorney. Sometimes it can be if they're indigent, but if they're not indigent, then they're going to pay for that attorney. And ultimately, the ward pays for everything. The ward eventually, if there is a guardianship put in place, they're going to have to reimburse for the filing fees, all the attorney's fees. It can become very expensive and it's intrusive. Guardianship's intrusive in your life. The government is now involved in your intimate details of your life. And it's expensive for the lifetime of that person until they pass away. The guardianship lasts for the whole lifetime.
So I guess a moral of this story is we are so much better if we can do crisis planning, meaning that we are trying to think of these things ahead of time and put those protections in place while we have the luxury of time to think ahead.
Right. So I call that proactive crisis planning.
Okay.
So actual crisis planning is usually going to be while we're in the thick of it and we're trying to figure out what our options are, what we can and can't do. And it's very time sensitive because there's a big bill coming and we're trying to avoid that big bill or at least keep it as low as possible.
Right.
And that, and oftentimes because of the time crunch, there may be some options that aren't available to us. Whereas if we're proactive and we think these things through ahead of time, have documents in place ahead of time, then usually we have a lot more flexibility, a lot more options available to us. And then if we have to involve the courts, then your time is a problem because courts are slow.
Yeah.
Even when there's an emergency, it's still not as fast as you would hope it would be.
Right.
Yeah.
So let's go into, if we were going to do this, what I would call the right way. We so often in the helping seniors world, we use Joe's term aging plan, and then we adopt we call it a euphemism, but we say getting your ducks in a row. And one of the things that we say, this is why it's to your advantage to do these things early. because it's going to be a lot less expensive. It's going to be a lot less stressful. It's going to be that you have many more options and ways to approach something than if you're just, your back is up against the wall and now whatever is going to work is going to be the only way that does it. How do you sit down with folks and say, okay, let's do this the right way. Let's do crisis planning the right way. What does that look like?
So proactive crisis planning, when you're doing it ahead of time, is usually going to involve an estate planning consultation.
Okay.
So when I meet with someone for estate planning, I think of two things. I think of, how do I take care of this person if they lose capacity and can't take care of themselves? And how do we take care of this person's family after they've passed? How do we take care of their stuff, the division of their assets, things like that? So it's two-part. And if we have an eye during that conversation towards Medicaid being a real possibility, then we may talk about doing some advanced Medicaid planning as well as part of that conversation. So it could involve multiple types of legal documents, maybe a trust if it's appropriate. A will usually is going to be appropriate at a minimum. Durable power of attorney, for sure. That's absolutely the most important document a person over the age of 18 can have to avoid guardianship. And for Medicaid planning, crisis planning, it's a powerful tool. And then the designation of healthcare surrogate, which also is a very powerful tool in avoiding guardianship and helping with crisis planning as well. There may be some other documents that we may discuss as well, just depending. It's all very case by case.
Right. I know we've had this expression and we sometimes joke about it, that if you don't make a plan, the government has a plan for everything. It just may not be the plan that you had in mind. And it really does seem like if you sit down and you do what we're talking about here, proactive crisis planning, it means that you get a chance to be in the driver's seat and think about how you would prefer things to be done. Am I saying that the right way?
I think so. I think that is the right way to say it. And you are right. The government does have a plan for you if you fail to plan for yourself. It's better to plan for yourself so you're sitting in the driver's seat. You get to make decisions on who's going to be in charge, who's going to do what for you, how you want things to happen. But if you fail to do that, well, then the state of Florida's got a plan for you.
Yeah.
And so if you lose capacity and you don't have legal documents in place, the state of Florida says, oh, that's okay. Don't you worry about that. We'll just put a guardianship in place and you'll be the ward of the state.
Wow.
So there's that plan if you lose capacity. And then if you die in the state of Florida and you have assets that need to go through probate, the state of Florida's got a plan for that as well. And it's probably not what you would want, right?
Yeah. Yeah. And I guess that's one of the things that we've talked about. So many cases happen here in Florida. First of all, we've talked about over the years that we just get more seniors because more people are turning 65 than ever before. But also people are just flat living longer is another aspect of why we get more seniors. And then the third aspect is so many people are moving to Florida. And I guess that represents a whole lot of things to think about when you're doing this proactive crisis planning. Because you may say, well, no, we had the best attorney when I lived up in New York and they did everything and we're good to go. And that is not necessarily the safe assumption, is it?
Unfortunately, no. And so here's the premise is according to the United States Constitution, what is legally done like illegal documents in one state should be recognized as a legal document in another state. And that's true. But the problem is the logistics of actually using that document in the other state may not work out the way you think it's going to. So if you move to Florida, I really believe it would be in your best interest to have your documents looked at and probably update them to be Florida-specific documents, especially that durable power of attorney and healthcare surrogate as well, but the other documents as well. But definitely the power of attorney.
Yeah, because I saw you give a presentation here at Joe Senior Resource Center, and you were explaining something about that the whole power of attorney had changed in, I think you said 2011. And now if you don't initial certain things, the person that you're expecting to be able to do it doesn't have the right to do those things. And you said that, I think you called it superpowers or something.
Yes. So in 2011, the legislature, and approved by the governor, obviously, put into effect new laws that kind of revamped the whole power of attorney statute. And now there are certain powers that I just call superpowers, you know, like Superman. But those particular powers have to be initialed, and they have to be initialed right next to the power. And so if you have a durable power of attorney that was drafted anytime after, I think it was October of 2011 when it took place, and you look in that document, if it's, you know, Florida specific power of attorney, and you don't see initials in there, that might be a sign that you need to probably have your document looked at and maybe redrafted. And what's important there is there's a couple of those powers that have to be initialed that are super important for Medicaid planning. One being able to set up a irrevocable trust, or maybe a specifically state a qualified income trust. Because when you are applying for Medicaid, you have to, which is needed for long-term care, which is what we're talking about with that big bill comes in. And now we're freaking out because we might have this $15,000 bill to pay or somewhere around that amount. And we start talking about Medicaid. In order to qualify for Medicaid, which will pay for nursing home care, long-term care, you need to qualify income and you need to qualify assets. So asset limitation for Medicaid is $2,000 of countable assets. And that's pretty low. But notice how I said countable, right? Because some assets count, some assets don't count. And so we look at each asset individually. Also, you have to qualify income-wise, and that's where the durable power of attorney can become very important, is not only with the income but with the assets especially, is we may need to do some Medicaid planning to qualify you asset-wise. That may involve preparing a qualified income trust if you're over income. It may involve transferring assets legally and pursuant to the rules of Medicaid. You got to be super careful. Don't just give away assets because you could disqualify yourself. But I hope I answered that question.
That was actually the point I was going to say, is I have heard the horror stories where people go off-road and say, well, you know, my daughter was going to inherit the house anyway, so I just signed it over to them. Or you know, they were going to take over the bank account, so I just put them on as a signatory. And I understand enough to know that can cause that throws some monkey wrenches in when you're trying to set that stuff up the right way, right?
Right, yeah. So if you try to avoid problems with Medicaid or the nursing home, a lot of people say, I don't want the nursing home to take my house. It's really not the nursing home doing it. It's Medicaid looking to be paid back. But so some people may add their child onto their deed, or may outright give their house away, or may do some similar things with their bank accounts. You got to be really careful with that, because Medicaid will look at that as though you are doing this purposefully to qualify for Medicaid, and then they will attach a disqualification period. So Medicaid, when you submit an application for Medicaid, they are allowed to look back up to 5 years to see if you've gifted any amounts away or gave your kids or grandkids funds of money, assets, income, or property, asset of any type, including adding them on, can be considered gifting. And then you could be disqualified for whatever period of months that works out to be. So what Medicaid does is it decides what is that divisor amount. And let's just say it's $10,000 a month. It's not. It's a little less than that. And you gave away $100,000. Medicaid will take that divisor amount, divide it into the amount you gave away, and you'll be disqualified for that many months.
Wow.
So it's $9,000 some odd dollars right now, but I'm going to use 10,000 just for easy math, because I don't do math well in my head. So if you gave away $10,000 or $100,000, and we said the divisor amount was $10,000, then you would be disqualified for 10 months of Medicaid, and that can be devastating.
Yeah, when you're talking $12,000, $15,000 a month that you're trying to get help with, Wow. So, that comes back to another thing I've heard you talk so much about is that people will get they think they're getting good advice, but they end up getting terrible advice. Maybe they saw an ad on TV and they did, you can do your own estate planning. You just click here and click this button. And then, or maybe a well-meaning friend at church, or you saw a card on a bulletin board at a grocery store or something, and you get in touch with someone and say, oh, we can do this. It's real simple. We'll help you fill out your form. The problem that always comes back to me when I think about those is you don't know what danger you're in until you need that to work. And then you don't really get a chance to redo it at that point. It's all over at that point.
Right. And the reason why is because most of the time we don't test our documents. We don't test them. We don't use them until we need them.
Right.
And what usually triggers that need is a capacity issue.
Yeah.
So your loved one has suffered some kind of health issue typically, and now they don't have capacity anymore to take care of things on their own. You're going to now take that durable power of attorney and try to do work with it. And then you find out it's defective.
Yeah.
Or there's some problem with it. Maybe it doesn't have the superpowers.
Right.
Maybe it does have the superpowers, but you didn't know you needed to initial them because when you do those types of documents, they give them to you and it's up to you to get them signed and notarized and everything. Yeah. And maybe you didn't know how important it was to initial off on things. We see that all the time.
Yeah.
Yeah.
Incredible. And there's another part to this too, is like when people are thinking about this, I guess the cost savings that you have, it's just like, I guess we said, get your ducks in a row. We said, don't try this on your own, but we added another corollary to that, which we say is, don't be an ostrich. Don't put your head in the sand, because these things don't get better with time. It seems like you'd be wise to sit down at your earliest possible and put this in order, because you're going to get so much peace of mind. You're really doing this for your loved ones and your family too, right? Because then they're going to know everything is buttoned up, and then you're not going to have to worry about it. So it seems like it would take like a load off of your mind. Like, what if something happens? But no, I know what we're going to do if something happens.
Absolutely. So it's good to have a plan. It's good. Well, what's important here is making sure that you meet with an elder law attorney, someone who practices regularly in estate planning, someone who understands Medicaid and the rules of Medicaid, so that when they're putting your plan together and helping you think about strategies moving forward, they can give you good advice on how to set things up so that you do have a plan. But I do want to make sure that it's not a one and done situation, that you should periodically have your documents looked at just in case things change.
Because family situations change. Somebody marries somebody gets into some sort of situation where they're not appropriate to be able to help anymore. You have all those different things. And if you didn't change your paperwork, you're probably stuck with whatever was there from back then.
Right. So it's recommended by experts to have your documents looked at every 3 to 5 years, just because the law changes and life changes. But triggering events, definitely. If you have someone in your plan that you're either going to have as a decision maker for you, or maybe it's a beneficiary, pass away, you need to have your documents looked at. If you have one of those people, a decision maker or a beneficiary, lose capacity, or their life has a major change going on, you might want to have your documents looked at to make sure that you still have a good plan. Also, if you get married, that changes things.
Yeah.
And you pretty sure you need to go get it looked at, right? Because when you get married, it changes the rights of your spouse. They have rights. If you get divorced, or if you're contemplating divorce, I think it's important to have your documents updated if you are contemplating divorce, because if you lose capacity or something happens to you, do you really want your angry husband or angry wife making decisions for you?
Wow.
I know I wouldn't. Also, if you have births in the family, or, new babies, and you set up your plan to only take care of certain grandchildren, but now you have a surprise grandchild and something happens, you wouldn't want that new grandchild to be left out, right?
No.
So births, deaths, marriages, divorces. If you move to a different state, you definitely need to have your docs looked at.
Yeah.
And then just time itself with the changes of the law and stuff too.
There's so many parts to this equation. This is really why you don't need to try to wade into these waters yourself. You need to get the help of an attorney, and especially one, we talked about this before, one who is an expert in specifics of elder law, because I know we joked about it, but it really wasn't a joke. That you actually explained on a radio show once about somebody who came into your office and had literally, I guess, had some experience with a criminal defense attorney, and somehow that person said, "I'll help you write your documents," and then they got into your hands. You're like, "Ooh, we got some problems here."
Yeah. So this particular person came to me to get some updates.
Yeah.
And of course, I ask, do you have any prior documents? And they hand me these documents that are written by a criminal law attorney that I actually know. And they were a mess. And I let him know, the criminal law attorney, that this was bad. This was really bad. Please don't do this anymore. Yeah. And we updated all the documents. No harm, no foul in that situation.
But it could have been.
But it could have been. It could have been terrible.
Wow.
Right? Yeah.
Wow. So we've been talking with Ruth Rhodes, board certified elder law attorney, one of only two at this time here in Brevard County. So you not only, this is your specialty, but you are at the top of the game as far as that goes by having all that extra review and extra, I guess I would call it, it's probably not the right word, accreditation. Ruth, if people want to get in touch with your office and take this to another step, what would you say?
I would say there's lots of different ways to contact me. You can call my office. That number is 321-610-4542, 321-610-4542. Or you can go to my website, because you can contact us through the website as well. And that's www.rhodeslaw.com, and I'll spell that. It's RHODESLAWPA.com. And we have a way to contact us through the website as well.
Good. Well, thank you, Ruth, for joining us, and we'll see you on the next edition of Helping Seniors TV.
I'm Joe Steckler. Thank you for joining our program today. I'd like to remind you that our senior information line is available to you at 321-473-7770. There you can get help and direction that could be helpful for your specific situation or circumstances. The work of helping seniors is very important, but we can't do it alone. That is why our sponsors here in Brevard County are so important. I'd like to thank our many area sponsors, businesses, and medical providers who support the mission of helping seniors that help us carry the cost of our media efforts. If you'd like to join us either as a business partner or simply donate as an individual, we welcome your call at 321-473-7770. You are always welcome to visit our website at www.helpingseniorsofbrevard.org. Thanks so much for your help. It does make a difference.